Under Charles, recklessly caused physical injury to another person, all of which is a Class A misdemeanor offense being contrary to and in violation of Alaska Statute 1141-230A1 and against the peace and dignity of the state of Alaska. Do you understand what you're charged with?
Yes.
And you understand that Class A misdemeanor, which means by law it can carry up to a year in jail and a $10,000 fine, and again, the agreement is that it would get a year in jail. You understand all that?
Yes.
And to that charge, what plea do you enter today?
Guilty.
So, Ms. Wolfstead, there's a criminal complaint on file which contains some factual assertions. Are you using those for a factual basis?
I'm sorry, Your Honor. I clicked speaker instead of mute, and I didn't hear the last thing you said.
Are you alleging the criminal complaint as a factual basis for the plea?
Yes, Judge.
Would find that there is a factual basis set out in the complaint. I would find that Mr. Charles enters his plea freely, knowingly, and voluntarily, and that he's competent to enter his plea. He's waived personal appearance. Ms. Wolfstead, anything you want to say about the sentence or the plea agreement?
Your Honor, I think this is an appropriate agreement. To the court's knowledge, Mr. Charles has 37 prior convictions. 5 of them are assault convictions. He would have been presumptive on a felony A3 by priors, and he does have multiple priors in 2018 and 2016 in terms of assault. However, given the minimal level of the injury in this case, and sort of all of the other things going on in the courts and in society right now, I think this is an appropriate agreement. It focuses primarily on isolation and deterrence, which I think are appropriate for somebody who's had 37 different options to reform their behavior and haven't. And so I would request the court accept it.
Let me just clarify a question. Because the judgment needs to designate that, I don't see that it's asserted that this is a domestic violence offense. Is that correct?
That is correct. It is not a domestic violence offense.
All right. Thank you. Mr. Miller, anything you want to say?
No, Your Honor. I just urge you to accept the agreement.
All right. Mr. Charles, you don't have to say anything, but you have a right to say anything at all that you want to say before the court formally enters sentence. Anything you want to say today?
Nothing really.
All right. We'll accept the agreement. I think the sentence that's set forth under the plea agreement is a maximum sentence for the reduced misdemeanor charge, and I think based on Mr. Charles' pretty extensive prior record, I can make a finding that he's a worst offender for the assault the 4th degree charge. Not saying he would have been if he was convicted of the felony, but as to the reduced charge, I would make that finding, which supports accepting the plea agreement. I would therefore accept the plea agreement, impose a year in jail. Required to impose the mandatory surcharges, and that's a $100 misdemeanor surcharge and a $100 jail surcharge. I want to make sure I've got that right, because Ms. Wolfstead, do you believe that's correct? I just want to double check the surcharges, the new surcharges this year.
You know, Your Honor, I'm not super clear on the new surcharges. I can tell you that this was an offense committed in January 2020, so it is within the new surcharge scheme. I thought it was $100 for the misdemeanor.
I misspoke. The $100 misdemeanor surcharge, it's a $50 jail surcharge, so it's a total of $150. I think I said $200, and so it's $50 less. There's no probation. There's no suspended time. And it doesn't look like there's an issue of restitution, Ms. Wolfstead. Is that accurate, as far as you know?
That is, Your Honor.
All right. So that'll be the order. Anything else on Mr. Charles's case?
No, Judge.
Good luck to you, Mr. Charles.
That's all we had, Your Honor.
All right. Thank you, officer.
Thank you.
So we also have Mr. Webster on the counter. Is Mr. Pallenberg on the phone?
Yeah, Matt Tellerico for Mr. Fuchs.
Is Mr. Peloso on the phone?
Yes, Ms. Peloso is there.
All right.
Yeah, I'm here too.
Mr. Webster's on the line?
Yeah, I'm here.
Correct. So Mr. Webster's on the calendar for arraignment. Bear with me a second. I'm grabbing his file. So this is a petition to revoke probation. Mr. Webster was sentenced back in February on a reduced charges of attempted vehicle theft and resisting arrest, was placed on probation at that time, and then the state has filed a petition to revoke, which alleges that Webster, after that time, was convicted or was charged with driving without a license in a separate case, G2267. Mr. Webster, have you actually seen a copy of that written petition?
I have not actually seen a copy of that.
Okay. Mr. Peloso, can you just clarify? I guess I'm not remembering whether you were court-appointed or not on that prior case.
I'm court-appointed on the underlying plea deal. I'm not court-appointed on the new driving with license charge.
Sure. Bear with me a second. I want to just pull that case up in court view. I want to double-check the status of the new charge. 2267. There it is. All right. So, indicates that Ms. Lee represents Mr. Webster on that charge, and it is set for status hearing April 30th, 3 days from now. It had originally been set for trial in March, but because of the COVID thing, that trial, I think, was vacated, I assume because of COVID, and so there's a status hearing in a few days to figure out how to reschedule that. Mr. Webster, you have court-appointed counsel on the new charge. Based on the determination by the district court that you're eligible for counsel, I would appoint counsel to represent you in this matter as well. I'm not sure that would be Mr. Peloso or the public defender. The process, I think, would be if you want me to appoint counsel for you, I would appoint the public defender. If they feel like the conflict that they had before continues on, then they would move to withdraw.
Yeah, no, I mean, I'm sorry, Your Honor, but that's actually the original court hearing, and I thought, like, for my driving without license and the petition thing was all the same thing. So.
Right. They're going to have to be, well, they don't have to be, but at this point they're on different tracks because the driving case, the new driving charge, is assigned to Judge Swanson. And so you've got the court date April 30th at 9 a.m. with Judge Swanson. And then the charge of probation violation is assigned to me.
Well, I was charged with all of that at the same time, so, and court appointment. So I just don't see how they got separated, you know?
I mean, they got separated because the one case is assigned to me and it was assigned to Judge Swanson, so they're kind of on two tracks. I don't mind having Judge Swanson handle it all. Can't be the other way around because I'm not going to do the driving without a license charge.
Okay.
But because it's a misdemeanor conviction, I guess as far as I'm concerned, I'm fine with the new, with the PTR, with the petition to revoke being handled in district court. I'm sorry, is it Ms. Wolfstead for the state on this? Not sure if I asked.
No, Judge, this is Ms. Gibson.
Do you have any objection to me simply setting this PTR on that same date on April 30th for further proceedings with Judge Swanson and just letting the district court deal with them all?
That's fine with you, Judge.
Seems like that makes sense. And then Mr. Webster doesn't have multiple court dates to try to keep straight, and you know they're kind of they're obviously related matters. He may have to have two different lawyers because one's a state matter, one's a city matter, but it seems like it makes sense for them to get dealt with at the same time altogether. So, Mr. Peloso, I guess what I'm inclined to do is appoint the public defender, calendar it with Judge Swanson, that same court date, April 30, 9 a.m., and then kind of see how things unfold from there. Does that make sense?
I think that makes sense, Your Honor. And I'll wait to see what the public defender wants to do, if they want to handle this case or how they want to do it. But definitely the the PTR is obviously completely connected to the underlying new charge. So I think that having both handled at the same time is probably the most efficient way to do it.
Right. I mean, I think it is possible that there's still a conflict, but I don't know that for sure. I think, if I remember right, that actually, by coincidence, the conflict had to do with Ms. Heim, who we just had earlier on this calendar, because I think she had a prior petition to revoke that alleged that she was having contact with a felon, meaning Mr. Webster. And I think because that was pending at the same time, I think that's the conflict that caused you to be appointed to represent Mr. Webster on this charge. I may be mistaken about that, but if that was the conflict, it probably doesn't exist anymore because that charge is over and done with, and she's not charged with that now.
And that's fine, Your Honor. I'll do whatever the public defender office asks. So if they want to take it, that's fine. If they want to hand it to me, I can take it also.
All right. So I will drop an email to Judge Swanson just to let her know that I'm suggesting that that's the best way to handle this. I assume that that's okay with her, but it's her court and it's her call. And if she says no, I don't want to deal with it, she'll send it back to me. I doubt very much that she will do that because that's not the sort of thing she does. But I will drop her an email just to make sure she knows what's going on. And Mr. Webster, that way it's going to be simpler for you not to try to remember multiple court dates. Does that make sense?
Yes, it does.
All right.
Thank you.
So April 30, that's 3 days from today, 9 a.m., that is, I believe, Thursday. Call in again and talk with Judge Swanson, and then she'll figure out what happens next, okay?
Okay, it's not at 2:30?
It is, let me double check. I had it up a second ago. It says 9 a.m. in court view.
Okay, cool.
And I guess I think I do need to say, just because this is an arraignment and you haven't previously appeared in court on this, I will order that you're released on your own recognizance on this case on the condition that you don't violate the law. That includes the law about not driving without a license. Ms. Gibson, any other conditions you think there ought to be? If you're on, you're muted, Ms. Gibson.
No, Your Honor.
All right. Thank you. Mr. Webster, you're good to go. You can hang up.
All right, thank you. All right, thanks.
Thank you, Your Honor.
All right. And then we have Autumn Baldwin on the line. Mr. Miller, are you still with us?
Yes, Your Honor.
And,
Yes, I'm here.
And Ms. Baldwin is on the line as well. Who's here for the state on this one?
Hannah Siebold, Your Honor.
So I think that the reason Ms. Baldwin is on the calendar is that there was a charge of violating conditions of release filed. It was added as count 2 in 1JU 20-60 CR. There is also another case, 1JU 20-308 CR, in which Ms. Baldwin is also charged with violating conditions of release. I don't think she's been arraigned on either of, well, actually, she was arraigned on the 20-308. That's the one that charged that back in February, Ms. Baldwin allowed her ankle monitor battery to expire. 20-60, the count 2 violating conditions of release alleges that Ms. Baldwin went to Fred Meyer without permission, went to Fred Meyer after having been ordered not to be on the premises of Fred Meyer back on April 1st. I think there may be another VCOR charge, if I'm remembering right, that also charges that she went to Fred Meyer without permission, or went to Fred Meyer.
Your Honor, you're correct on that, but I think that's a city case.
Okay. So, Ms. Siebold, one charging issue.
Yes.
The information adding misdemeanor count to indictment, which was filed April 7th, alleges in count 2 that on or about December 24, 2019, she violated conditions of release. The affidavit, though, alleges that she went to Fred Meyer on April 1st. And so I think it seems to me that date, the date of the actual offense that's alleged in the text of the charging document, appears to be inaccurate.
Okay.
And I wonder if you are wanting to amend that.
I would move to amend, Your Honor. I'm sorry, I'm getting a little bit of, my
computer is just crashing and I'm not having access to seeing exactly what you're looking at. So, but
Yeah,
yes, we would move to amend.
And actually, I said April 1st. I think it actually, the affidavit says that she was at Fred Meyer, March 31, 2020, shortly before midnight. So,
Yeah, I
Mr.
think
Miller,
it said.
Mr. Miller, I am writing in on the court's copy of the charging document that it's on or about March 31, 2020, the date of the alleged offense. You want me to read that to Ms. Baldwin and advise her again of rights and penalties?
No, that's fine, Your Honor.
So we already have, well, we had a trial date in April. The matter's been continued a couple of times because of the COVID situation. It is currently on the June trial calendar, although I think it's probably doubtful that it's going to be able to proceed at that time. But it is calendared for trial in June with a scheduling, with a calendar call Tuesday, May 26th at 11 a.m., which is the next court date on that charge. And so I think in terms of scheduling, that's that. Ms. Siebold, we had a conversation last week at the earlier court date. Ms. Baldwin wasn't present then, but there was some concern expressed about Ms. Baldwin's compliance with conditions of release, and the state asking for any change in her condition for her bail.
We're not asking for any change in the conditions, Your Honor, but we would ask the court to perhaps reiterate what those conditions are and to explain to her that she is not to be on Fred Meyer property. Obviously these are not the most serious sorts of crimes, but on the other hand, the court ordered her not to do something and she needs to listen to the court's order.
Mr. Miller, anything you want to say about that before I start talking to Ms. Baldwin?
No, Your Honor.
So, Ms. Baldwin, this isn't your trial. We're not here today to discuss, whether you're guilty or not guilty of the things you're charged with. That's going to get sorted out later. No one's asking today for you to go to jail. No one's asking for me to change your bail. But I want to emphasize to you that when the court sets conditions of release, that they have to be followed. And I think you're probably, that there have been several allegations that you violated conditions of release. I think you probably have run about out of chances and to be charged with another violation and not go to jail. So, if there is another allegation of a violation of conditions, I will issue a warrant, and we'll send you to jail and then figure out if you should stay there.
Yes, sir.
So just, again, I'm not asking you to respond. I don't want to hear your version of things. That's something you can talk to your lawyer about, and you'll get your chance to present that later. And I understand that, at this point, it's only a charge, and you're presumed innocent. And so, I'm not here, again, I'm not trying to get you to make statements about what you did or didn't do. Just to emphasize, the condition of release not to go to Fred Meyer means more than just don't go in the store. It means don't go on their property, don't be in the parking lot, don't get gas there. You don't go on the premises of Fred Meyer, whether they're open or closed, after hours or during business hours, just so that that's really clear. Is that any questions about what what the condition is? Do you understand the condition of release?
Yes, sir.
Okay.
No
I think that, all right. I think that's probably all we can do today. Ms. Siebold, anything else on this case today?
No, Your Honor. Thanks very much.
Mr. Miller, anything else on this case today?
No, thank you.
All right. Thank you. Ms. Baldwin, you can hang up. And I think the only case that's left is Mr. Fuchs, unless I'm mistaken. Mr. Miller, do you think you have anything else?
It doesn't look like it. No.
Thank you, Mr. Miller. You can
Thank you.
sign off. We'll turn to Mr. Fuchs' case. So we're on record on State of Alaska versus David Fuchs. I'm not sure that we have Mr. Fuchs on the phone yet from Lemon Creek, though.
Mr. Fuchs, are you on the line? No, I have to call.
All right, so we're going to need to call them. We'll patch Mr. Fuchs in here momentarily. Mr. Talarico, you're still there?
I'm still here.
All right, stand by. We'll get him.
Okay, hold on just one moment, Mr. Talarico.
Are we supposed to tell them when we're here? No, we could. Those missing pieces, I bet they go. hot grass there, how that one grass.
Mr. and Miss Swanson, we can hear that you're on the and the court will give you the option, but what I'm going to ask, it's not your turn to speak, if you could just mute your phones like the rest of us are doing, so that it doesn't create that background noise.
Okay, all right. And then you'll tell us to be talking?
Yep, I'll let you know when it's your turn.
Okay.
All right, thank you.
Thank you.
Okay, Mr. Fuchs, can you hear me?
Yes.
Mr. Tallarico?
Yes, I can.
Thank you.
All right. We are on record in the state of Alaska versus David Fuchs. I believe we have Mr. Fuchs on the phone. Mr. Fuchs, can you hear me all right?
Yes, sir.
All right. Mr. Tallarico is with us for Mr. Fuchs. Mr. Tallarico, can you hear me all right?
Yes, General, I can.
All right. And is it Ms. Wolfstead on the phone for the state?
It is, Your Honor, and I'll also let the court know that the Swansons are on the phone as well, and that they will, when it's their turn, like to speak to the court about Mr. Fuchs' bail request.
All right. Can you folks hear me all right, Swansons?
Yes.
All right. Mr. Tallarico?
Yes, thank you, Your Honor. The request, I have it from 20,000 down to 0. I'm just going to say, put it that way because I've done a couple of these bail hearings, and I know the courts are in a position to, try and weigh things. So trying for me to come with a specific dollar amount is kind of difficult. But the argument here is that with the pandemic and the COVID-19 outbreak, especially at Lemon Creek there, there is some definite health concerns that Mr. Fuchs is literally facing there. I know some remedial situations include social distancing. I don't know how effective that can be in a confined quarters at Lemon Creek. We're asking for a reduced amount, nominal, as Mr. Fuchs is indigent. And Mr. Fuchs is also willing to abide by any condition the court wants to impose. It could be PED, electronic monitoring, any condition that the alleged victims would feel comfortable having. It's just an unforeseen change in the country's history here to have this happen, and the court needs to strike a balance between safety to the community as well as safety to Mr. Fuchs and safety to other inmates as well. And given how it's alive and well with, I believe, 4 confirmed cases at Lemon Creek, that the threat there is real. Which is why we're asking for a reduced amount. I know I put 0 there. Ideally, we would like to have something nominal, and Mr. Fuchs would abide by any condition asked by the court, any condition that the alleged victims look to have put out there. Mr. Fuchs would be happy to abide by as well. And that's about it, Your Honor.
Thank you, Mr. Tallarico. Ms. Wolfstead, do you want to be heard on that, or do you want me to turn to the Swansons first?
Your Honor, I'll speak first, and then we can turn to Swanson's. The state strongly opposes this request. While the court certainly does have to look at the safety of Mr. Fuchs and the fact that there are 7 cases at Lemon Creek, all of them were jail guards. I don't believe any of the inmates have tested positive at Lemon Creek. I think the only place we've seen an inmate test positive was at Booth, was upstate, not here in Juneau. And I'll note that certainly that's something the court is considering across the board right now because it's a pandemic and it's serious. But what's also serious is protecting our community from people like Mr. Fuchs, who've shown that he's a danger to the community. And I'll note, I'm going to go through, I know the court knows at least that the allegations are fairly well. We've talked about them in significant detail previously. I'm going to assume the court generally remembers that. And if the court has any questions, I'm certainly willing to address those. But as far as his history, he's got a 2018 interfering with officer on duty, 2017 driving without a license, 2017 assault, 2017 another driving without a license, 2015 theft 3, 2015 larceny out of a separate case, a felony theft, violating conditions, 2013 misconduct involving a weapon in the 4th degree, 2007 assault, 2006 assault, 2000 promoting contraband. So Mr. Fuchs is double presumptive and in fact has a 3rd felony assault from the earlier 90s. Drug convictions, disorderly conduct, resisting arrest, minor possessing or consuming. And what's clear is that through his entire adult life, what has been pervasive for Mr. Fuchs is the criminal justice system has been involved. And it's because he is a danger to our community. I don't think that reducing his bail to 0 and releasing him is something that meets the requirements of the bail statutes, even looking with COVID-19 in place. And so the state would oppose the request. I believe the Swansons do as well, and I'll let them speak to that.
Mr. or Ms. Swanson, either or both of you want to be heard today?
Yes. I'll start. I am very opposed to this, as are many other members of our community who would have been happy to sign an affidavit to that effect had we known it was going telephonically. The fact that I still have missing firearms in the community, that only Mr. Fuchs knows where they are, does really not make people feel safe. I know it doesn't make me feel safe.
Welcome to Ready Access by... Thank you. Please stand by. You will now be placed into conference.
Pretty safe place for him to be at this time, Your Honor. I just would we just need to be safe out here, and I wouldn't feel safe with him out in the community. I just, based on his prior behavior, he doesn't have a good track record, so I just believe that we need to go to trial. Thank you.
Your Honor?
Yes.
I'll add one more thing, which is this case, as the court knows, is set up first up in your courtroom for trial. I think that at the end of this bail hearing, I'd like to talk about a couple things as a status because I just have some concerns about, I've got one out-of-town witness. I know Mr. Tallarico is coming from out of town. I'd like to discuss that briefly at the end of the bail aspect of this hearing. But I will note that we're talking about Mr. Fuchs as being, per your order, whenever we start trials again, whether it's June 1st or a little bit later. I'm not quite sure when that will be based on the virus right now, but that I think we all sort of recognize that Mr. Fuchs is first up.
Mr. Talarico, I'll give you the last word if there's anything else you want to say.
Yeah, I look at Mr. Fuchs's record. You know, we aren't going to deny it. There's a lot of things there, but the way I look at it, and I don't want him to get mad at me when I say this, is I think it's more viewed as him being more of a nuisance in the community than someone that's dangerous and violent. When I look at the record, there's maybe an assault from 2017, a misconduct involving weapons, I believe, in 2013, and then we go back over 10 years ago, and there's another assault. It looks like it's a misdemeanor assault. But a lot of it is there's interference with the officer and duties, driving without a valid driver's license, another driving without a valid driver's license, theft, larceny, violating conditions of release. But Mr. Fuchs, he has no intentions to abscond. From Juneau, he wants to stay in court, to have his innocence, presented to the jury. If these of all his recent criminal convictions are violent ones like robberies or a lot of assaults, I'd understand that, but I don't view it as him being a violent criminal, more or less just the unfortunate term of a nuisance, more like maybe annoying in some regards, but like I say, I mean that with no disrespect. I'm just trying to paint the picture differently here, that he's not a violent offender. He's just an individual who's had some prior criminal convictions. And I think the court should consider weighing that as a past criminal conduct, at least the types of convictions that they are in reducing the bail to a smaller amount. And like I said, Mr. Fuchs is willing to abide by any conditions, the court wants to impose. If there's something that the alleged victims would feel safer with, or would like to see done, he'd be happy to, oblige and, accommodate that as well.
All right. Thank you, sir. Well, I want to start by saying that I suspect that the people who believe that Mr. Fuchs ransacked their home and stole a variety of items that meant a lot to them and items that are potentially dangerous like firearms might view it as a bit more than a nuisance or an annoyance. I want to talk a little bit about COVID. First of all, the Court of Appeals has entered an order which all trial judges are bound by, which says that the court is obliged to consider the pandemic in setting bail and deciding on release conditions. And I don't discount the issues posed by being in jail in the midst of the pandemic. I mean, I don't think that one can say that Mr. Fuchs is safer from the virus sitting in jail than he would be out in the community. I mean, when you've got roughly 200 inmates in a confined space, by definition a confined space of a jail, I don't know that social distancing is possible in a jail. I suppose if you had a huge jail with only a few inmates, you could keep them far enough apart that nobody would be in contact with anybody. But the fact is, Lemon Creek, isn't large enough to keep everyone apart from everyone else. There's a certain number of inmates that can be kept in isolation cells, but there aren't 200 isolation units to keep people apart from one another. And so I don't discount that. You know, I think it's been the case around the country that when the virus has gotten to inmate populations in a jail, that there have been some jails where a lot of inmates have tested positive. I've heard, you know, figures out of Ohio that are alarming, and other places. And so I don't discount that, and the Court of Appeals has ordered judges not to discount that. I think it bears noting that of the 7 positive tests in Juneau, they're all correctional officers. I don't know how many inmates have been tested. The numbers I saw were fairly small in terms of the number of inmates who've been tested. And the fact that there haven't been any inmates that have tested positive up to today doesn't mean there aren't going to be inmates testing positive tomorrow. So, you know, I recognize that the risk is there. The risk is there outside of the jail, too. We're all at risk. But I recognize that the risk may be higher in a jail setting. I think it's not just inmates. There are people working in places that are where they're obliged to work, whether they're first responders or people in a hospital or people who work in a grocery store who are at risk as well. So, you know, on some level, we're all at risk. I don't really need the comments, if you wouldn't mind. I think it also should be noted that I haven't heard any assertion that there's anything about Mr. Fuchs that puts him at higher risk. Again, I'm not saying we should shrug our shoulders at the risk of him getting infected or any of the rest of us getting infected. But, you know, we're not talking about somebody who I'm hearing has a respiratory illness or something else that puts him in a higher risk category. The Court of Appeals issued an order in the case of Carr, K-A-R-R versus State, in which the Court of Appeals directed trial judges, again, to consider the COVID-19 situation in making bail determinations. And the Court of Appeals in that case, this is their words, not mine, has indicated that the coming of the pandemic is a changed circumstances which requires the court to hold a bail hearing on request and that the court should take into account. And I'm trying to find the language I was looking for in that decision. Bear with me just a second, because I'm scrolling down through it. Courts must now balance the public health safety risk posed by the continued incarceration of pretrial defendants in crowded correctional facilities with any community safety risk posed by a defendant's release. Additionally, courts must reevaluate the flight risk and safety risk posed by releasing a defendant into a community which now has fewer open businesses, fewer opportunities for travel, and more people staying at home. The court went on to say that trial judges should consider, the court said that other jurisdictions have considered other approaches, including encouraging trial courts to release low-level nonviolent offenders. And then the court talks about some other issues that aren't at issue here. I have released low-level nonviolent offenders who I would not have released before the COVID-19 situation. I have set lower bail in other cases because of the pandemic, because I think it's appropriate in that balancing to consider the need to try to reduce jail populations to minimize the risk of the virus spreading. And it should be noted, it's not just a risk to the inmates, it's a risk to the correctional officers, it's a risk to their families. And those are all appropriate factors for a court to consider. But as the court said in Carr, it's a balancing. And the court doesn't simply cut everybody loose because of the COVID pandemic. The court balances the risk from the pandemic with the risk to the community of releasing a defendant. Mr. Fuchs is not a low-level nonviolent offender because of his record. Considering that balance, I continue to believe that Mr. Fuchs poses a risk to the community. He has a demonstrated risk of not complying with conditions of release, of offending and reoffending, and He has a long and varied criminal history, including both violent and nonviolent offenses, and a range of different types of offenses. And so, while I think it's appropriate to consider the virus, I'm not willing to simply release Mr. Fuchs on his own recognizance, because I think he poses a real and ongoing risk to the community. So I will deny the request. In terms of the trial date, let me start by saying I issued a written order that I know council has seen about the trial date. Because of the age of this case, because Mr. Fuchs is incarcerated, because of the many, many continuances, many more than I would prefer to have seen, I think for all of those reasons, this case should be first out of the chute when we resume trials, and that is my intention. The order that we have in place now is that the current moratorium on trials or suspension of trials is through May 31st, and this case is scheduled to start the first week of June, the first day of June, and I'm going to strive to hold to that date. There are things, though, that I don't have control over, and if the presiding judges, plural, issue another statewide order that extends that suspension, I don't have any control over that, and I don't have any choice in the matter. So, and I think that is possible. The word that I've been hearing is that I think there may be a phased reopening of the courts for full business. I think there's been discussion about the challenges that are going to be posed when we start up again in getting jurors. When we start doing trials again, which I hope is June 1st, we're going to have to do a lot of things to try to reassure jurors so that they will come in for jury service, because people are going to be scared. Some of those things are going to make trials much more time-consuming, because we'll need to handle jurors in smaller groups and allow them to maintain social distance. I don't think it's going to be practical to bring 40 jurors into a courtroom on June 1st, because they won't come, and we're not going to endanger their health by doing that. So we're going to need to handle them in much smaller groups. Probably that's going to involve a much longer jury selection process. There may need to be health screening when they come in. There's a lot of things that are going to have to happen. There are a lot of conversation going on right now about that. I have heard a suggestion from the presiding judge that we may start grand jury proceedings on June 1st, but trial juries, there may be some additional extension. I cannot speak for the presiding judge, and I haven't heard anything definite about that, but I fear that it's possible that there will be another order that extends that more. I don't know. And all I can do is go by what the presiding judge orders me to do. So, Ms. Wolfstead, in terms of an out-of-town witness, I don't know. I cannot make a guarantee that we're going to be able to start June 1st. I will try, and it's my intention that we'll start this as soon as we can start trials, but I don't know for sure.
Certainly, Your Honor, and I guess my specific concern, and I'm not quite sure exactly how we want to address this, is the requirement that juror quarantine, in essence, for 2 weeks under the current health mandates issued by the governor. So I'm just trying to figure out
right.
what we do about that. And I think that would also include Mr. Tallarico, who'd have to travel for this trial, and how he addresses that. So I wanted to bring that issue up. I also thought that depending on where we are, we may want to set a status hearing in this case, since we are first up, and it is a bit more of a complicated case in terms of the number of witnesses, that if we wanted to set a status hearing maybe in mid-May to potentially discuss, and I could get something submitted to the court and to defense counsel, an expanded juror questionnaire that maybe could get sent out. I know that was one of the recommendations made at the bench bar today. I think that's one that makes sense, and I can get all of those things submitted, but the more issues we can resolve pre-trial, I think that makes sense.
I think that's probably a good idea, is to have set a standalone calendar call in this case. Probably it should be set more than 2 weeks before the start of our trial. I'm not suggesting that I'm going to expect Mr. Tallarico to come to Juneau 2 weeks before our trial date so that he can quarantine before the trial starts, but that's actually, I hadn't even thought about the quarantine question. That's something I should have thought of. So why don't we set a status hearing maybe the week of May 11th? Mr. Talarico, does that make sense?
It makes sense, yes.
Thursday, May 14th. 11 a.m.
Is there another
that was-
time? Sorry, I didn't mean to interrupt. Is there another time? I'm already in an 11 o'clock hearing.
10?
I can do 10, yes.
Ms. Wolfstead, does that work for you?
It does, Your Honor. I would just request we make sure that works for the Swansons. I know they have been present at every hearing in this case, and I'm sure will want to be present then.
Mr. and Mrs. Swanson, does that time work for you, 10 a.m. on May 14th?
That works for us. Thank you.
All right, and it will still need to be telephonic again. All right.
Okay.
What we'll do. And we will try to get Mr. Fuchs on the Polycom at that point. I'm not sure why that didn't happen today, but we'll make sure, I'll at least put in a request that we get him on the Polycom that day. There's nothing else, we'll go off record. Thank you.
Thank you. Have a good day.
Thank you.
The chairperson has disconnected. The conference will now end.